Hi, everyone. Thank you for joining us today for our webinar with Orr and Reno, PA. I'm Emily Marsh from the Chamber. I want to thank you for coming to this. So we held a lot of webinars this spring with Orr and Reno. We're so grateful that they covered all these important COVID-19 topics, and we're really excited to continue a webinar series this fall and into the winter. So stay tuned for more topics and more events like this. So today I just want to explain to you how to use the Q&A portal, because our panelists are going to be able to answer questions from you if you have, something specific that you want to ask. So to submit those questions, what you're going to do is just move your mouse a little bit or tap your screen if you're on a mobile device, and you should see a button called Q&A. You want to click on that. You can click on it right now if you want to try it out. And you're just going to literally type in your question and submit it. Those questions will be seen only by our presenters and myself. So it won't be public to everyone else who is attending today. So again, you're going to move your mouse, tap your screen, click Q&A. Type your question in and submit it, and we'll see them. The questions will be answered at the end, so you may have to wait a little bit to get your answer. That's it from me for now. I just want to introduce Jennifer and Lindsay from Orr and Reno. Thank you again for joining us and presenting today.
Well, thank you, Emily. I'm going to take over and do the first half of the presentation. So I'll introduce us, and Lindsay is going to do the second half of it. Lindsay Nadeau is an attorney at Orr and Reno, and she does employment law as well as government relations. She does lobbying, insurance, and just general litigation. I also am an attorney there doing employment law as well as general litigation. So please reach out to us with either questions and answers during the seminar. If we're able to intertwine them to our presentations, we will, but so we don't lose the flow of what we're talking about, we're going to try and take those at the end if we have time. If we don't get to your questions, we will try and get back to you if we're able to get your email address, and if you want to put that in there, we're happy to answer questions after the seminar by emailing you directly. And I think that is it for our opening, but I want to just give you, Lindsay's going to be doing the slides, thank you. We are going to start off this morning looking at, we're assuming most of the businesses here have employees, that you're worried about COVID risks and liability as we head into fall and winter months, where in the past week, I think COVID cases have taken a slight uptick in New Hampshire. And as a business, running a business, being responsible for employees, we want to cover that first. We think that's a really important topic as to what the risks are there, as well as we're going to go into third parties. Maybe you're a school, a private school with students. You may have vendors, independent contractors, customers. We're going to talk a little bit about exposure and liability to those parties. And then the third big issue that you ought to be sort of looking at and concerned about is regulatory agencies, the government, who's stepping in to oversee whether there's liability or fines or other actions that need to be taken against businesses with regard to COVID and all the executive orders and guidance that have been put out both at the state and the federal level in terms of compliance. Lindsay's then going to go into how do you limit these liabilities, and I'm going to touch on that throughout, because really we want to make this an interactive session that we're not only sort of telling you first thing on a Tuesday morning about all the risks, but we're trying to help you in terms of how do you minimize those risks, how do you protect the business, and how do you shore up, whether it's through insurance or releases, or I think you're going to hear us talk a lot about guidelines and following guidelines throughout this, because that's another way to limit your liability. At the end, we're going to do some frequently asked questions if we have time, and your questions, although we'd much rather get to your questions than frequently asked questions. So that's our agenda for this morning. I hope you all have coffee because we're going to launch right into liability to employees. And to do that, you really need to understand, I'm assuming most of you have dealt with workers' compensation, but I wanted to give you a quick overview of what workers' compensation is, why it's there, because that's going to be your first line of defense for liability on employees and when they come down with COVID and whether they look back to the business or the employer for liability for it. So take a big swig of coffee because we're going to launch right into workers' comp. Workers' comp section 281A is a general sort of overview of it. Is it provides compensation to employees who have a workplace injury or illness. They receive money in terms of lost wages and medical benefits. They don't have to prove fault of the employer, but in return, they waive any personal injury claims that they may have. The workers' compensation bar is probably what you've heard a little bit. So in exchange for having to not prove fault for such injuries, they're not allowed to file a personal injury claim against the employer. The injury must arise out of employment. It must have a connection with the risks of employment. And usually courts look at different types of risk or hazard related to employment to do that determination of whether there's a connection between the risk and the employment. So the 4 types of general risks that the courts look at in workers' compensation are employment, covered. You have a person who fixes phone wires, they fall off the ladder, they fall out of the bucket. Clearly it's an employment related fall from a ladder. Personal, which are not covered, for example, heart attack at work or epilepsy, something that's just unrelated to work and yet the worker has an injury there. Those would not be covered under workers' comp. There's mixed, only, when there's both the employment and the personal. I gave the example of a worker with lung issues, maybe a smoker. So that's his personal issues, but then the workplace exacerbates that injury. So if you had an injury related to the lungs and that breathing, you'd have to do an analysis of whether it's the employment is a substantial contributing factor when you have mixed risks. Neutral risk is sort of neutral. It's unexplained, an unexplained fall. All of a sudden a worker on the assembly line falls, gets injured. What caused it? It's a neutral risk. So when we look at COVID cases, we typically, and this will be into the, let me just say with a neutral risk that workers' compensation is available when the risk is greater than that to which the general public was exposed. We're going to be talking a lot about this because there has been a letter put out, an opinion letter by the Attorney General that is going to tell us that, at least under the Attorney General's analysis, that COVID-19 is a neutral risk. So let's keep going and sort of analyze our workers' comp a little bit further. Take another sip of coffee on this workers' comp stuff. It can get pretty dense. The workers' compensation bar, which is in section 8, this is what I said, in order to give up that personal injury action and the employer and not have to prove fault, there's a bar to any personal injury action. So that's going to protect you as a business or employer if an employee comes in and says, listen, I got COVID-19, I think I contracted it in the workplace and I'm going to sue you. At that point, you go into analysis of, is it barred under 281A8 in terms of it should have been a workers' comp claim. So in order to do that analysis, you need to understand workers' comp, what the format is, as well as the workers' comp bar. And most employers, they're either self-insured or they have insurance for workers' comp claims. So happy to answer more questions, but I don't want to get too bogged down in workers' comp. So as I alluded to, the Attorney General in May of this year issued an opinion. Now, Attorney General opinions are advisory in nature. They are not binding on the court or the Department of Labor. So take this for sort of advisory opinions, but it's certainly not binding. And if a court gets a case along these lines, they're going to do a separate analysis. So under the Attorney General's analysis back in May, an employee must show that employment subjected him or her to a risk for contracting the virus greater than that to which the general public is exposed, because it's looking at COVID-19 cases as a neutral risk. So an employee can recover if COVID-19 was more probable than not related to work, i.e. the risk at work was greater than to the general public. Employers can defend these claims and say, no, it wasn't greater than to the general public because I followed the reasonable compliance, the guidelines in terms of setting up 6 feet apart, asking all employees the standard questions, taking temperatures, all the guidelines that apply to both the universal guidelines as well as your specific industry. That's how employers show reasonable compliance and thus show that the risk in the workplace is not greater than the risk in the general public, and therefore it's not a workers' comp claim, and the workers' comp bar protects them. So can we go to the next slide? So as employers protected from personal injury claim by the workers' comp bar, you don't, if it happens, it's in the workplace, you don't have a right under 281A8. And the employer can protect themselves from the workers' compensation claim by showing that the employment did not present a greater hazard for contracting the illness, that the employer was following all the applicable guidelines. Now we're going to talk a little bit more about this, but you need to be careful with looking at not only the state level guidelines, which we'll give you the website for, but as well the federal, the OSHA, the CDC, and any industrial operational guidelines that apply to your business. A lot of states have passed, I shouldn't say a lot, there are some states that have considered, the federal government in fact considered a liability shield law that would outright bar claims against an employer by employee or third parties. New Hampshire does not have that. The federal government did not adopt that. So there's no liability shield law with respect to employees and the exposure there. The one thing when we've gone through this whole workers' comp analysis, there's still the risk that a family member could bring a type of claim against an employer. For example, if your employee can show that he or she contracted COVID-19 in the workplace and then took it home to a family member, that family member is not barred by the workers' comp bar in terms of bringing a type of claim against the employer. So we're going to talk a little bit about negligence claims next, and the risk of a family member and liability to family members would be part of that. So tips to minimize employee liability, because what we don't want to do is just tell you of all the potential liabilities without giving you some means to minimize them for your business. So follow New Hampshire guidelines. Safer at Home, the universal guidelines, and we put the link right there, as well as all the industry guidelines are at the link that I've put in the slide. Check it often. I think it was amended August 27th with some updates, and I imagine that they're going to, the Governor Sununu will continue to update these guidances as more is known about COVID and as the situation changes. So please stay on top of that. Also review workplace guidance from the CDC, OSHA, and the EEOC. But all those organizations are addressing what employers need to do in terms of minimizing employee liability. And then finally, some things to consider are internally create a point person or a team to monitor COVID-19 developments. The last thing you want to do is put together a practice that is great and complies with guidance, but then the guidance changes. So you want to make sure you're keeping on top of it. It's an adaptive approach, continue to monitor. alter schedules and workflows. I think that's addressed in a lot of these guidelines. If people can work remotely, employers are encouraged to allow employees to do so. Keep them 6 feet apart, plexiglass in front of workspaces if you can. PPE, never thought we'd all know PPP and it would just roll off the tips of our tongue, but it seems to be something that all employers need to be aware of, provide to employees, sanitation supplies, make sure the workplace is kept sanitary. All these things we've gone over in previous webinars, but it's worth repeating and sort of putting this list here so that you can make sure that you're staying on top of it. Next slide. Third-party exposures. This is really going to be dependent on what type of business you have, and without knowing the participants we have on the webinar, it's hard to give very specific advice here, but some of the examples and things to think about are clients and customers who come in. If you have a retail operation, a restaurant, what's the liability of those people and what precautions and guidelines do you need to follow and take? Vendors, salespeople, maybe you have salespeople going out into other business locations. Maybe you have sales vendor people coming into your business. What's your exposure there? How do you limit it? And Lindsay's going to talk a little bit about that in her presentation. Visitors, as a law firm at Orr and Reno, we typically have clients, visitors coming into the office space. We've made the determination that we're limiting that at this point, but can you limit visitors and still do business? Can you have certain guidelines and procedures for those visitors? Contractors, independent contractors who come in, and again, that may be a little bit more in Lindsay's presentation on releases. What do you do with those? And then the general public, which sort of falls into clients, customers. The other thing that you may want to do if you're a private school, oops, cat, one of the joys of working from home. General public in terms of, again, students maybe if you're a private school, but think about all the people that come into contact with your employees and into your workspace. So these third-party claims are, there's no workers' compensation bar, they're more straight negligence claim that if someone's going to assert a liability action against the employer, they must show that the business is negligent and that negligence caused the person to suffer an injury, i.e. COVID-19 exposure and then contracting the disease. In the beginning of the pandemic, it was thought, the general knowledge was it was going to be very hard to bring these negligence claims because the causation, how do you ever show if someone's out and about in public that the actual causation came from the business or the employer, the point of contact that gives rise to liability. And we still haven't seen an abundance, we haven't seen any in New Hampshire that I'm aware of these types of cases. So it's still the court and jury are out as to whether a person is going to be able to show that causation or not. I still think it's going to be an uphill battle, but as the COVID-19 outbreaks have been more limited, it might be an easier hurdle to get over than we first thought at the beginning of the pandemic. Defenses, pretty straightforward, not negligent, followed the guidelines. We just talked about that. Another reason why you want to stay up to date on the guidance and following it. And then again, that it's not caused by your business actions or lack thereof. The person also went to the doctor's office and could have been exposed there. The person went grocery shopping every day and could have been exposed there. So again, refuting that causation element. And no state or federal liability shield laws. And one thing I didn't know before is municipalities also, I've read, have started following it. I'm not started enacting these liability shield laws. I'm not aware of any in New Hampshire, but again, it's something to stay tuned if to see whether there is a governmental entity, whether it's at the federal, state, or a locale level that starts addressing these liability shield laws, which are basically just saying you can't, it's like the workers' comp bar, you can't sue an employer for a COVID-19 related injury. But I don't think you need to worry or address that, because as far as I know, if you're doing business in New Hampshire, there are none of them out there at this point. Next slide. Again, I'll go quickly through this because tips to minimize third-party liability. Follow the guidelines. I sort of feel like you're going to get sick of hearing that, but follow the guidelines. Follow the guidelines. And then also, which Lindsay's going to touch a little bit on more specifics, is review contract provisions for third parties, vendors, contractors. Can you put in their release language or other assumption of the risk language that's going to protect you? And the last area that I will talk about before handing it off to Lindsay are regulatory liability, action from government coming in, and whether it's OSHA or the Department of Justice to determine that a business is not complying with executive orders or guidance, and either issuing warnings, fines, or there can be civil actions that are brought as well. So the first thing I want to talk about a little bit is OSHA. In the beginning, OSHA was not doing a lot of sort of fining or going into businesses. OSHA has no specific regulations related to COVID-19 safety. They do have a general duty requirement, and OSHA has cited to this to encompass an expectation that employers will make reasonable efforts to comply with emerging guidance, whether that's issued by the CDC or other regulatory agencies. So in September, OSHA went into Smithfield Foods in Iowa and issued what was the maximum fine, only $13,000 roughly dollars, for violating and not developing and implementing effective measures to mitigate the exposure to the virus. This was one of the meat packing plants, as probably everybody's heard about. So we don't know whether this is an indication that OSHA is going to start getting more aggressive in their enforcement measures, or whether they're not. Is the climate these days. OSHA has been criticized for a relatively small number of inspections and citations is made to date. And again, the Smithfield one may be an indication that OSHA has heard those criticisms and is going to take a different stance. So be careful, make sure you stay up to date on OSHA. New Hampshire Department of Justice, likewise, in the very beginning, I think it was back in March 30th, they issued a memo stating that they can charge people with a misdemeanor for disorderly conduct for not following the guidance put out by the governor. And they also stressed that the Attorney General's office was going to seek voluntary compliance. For a while, I think they fielded calls, but you didn't see a whole lot of action. You really saw them working with I think one of them was the Riverside Speedway in Groveton, I think made the news, but you saw the Attorney General's office really trying to work on compliance versus issuing citations or going to court. Just recently, they started, again, like OSHA, being a little bit more aggressive in the enforcement, and there was a recent $2,000 fine against the New England Flag Football League. And that was for violating Emergency Order 52 and the state's guidance. I believe Emergency Order 52 that makes those universal guidelines applicable and ones that businesses need to follow expires October 1st, if I'm not mistaken. So it'll be interesting to see what happens in the next couple of days. I have not seen, but I could have missed it, that was extended into the future. And again, the Attorney General's office was issuing some prior letters, but again, warnings about it. And just as a side note, Vermont has also not seen any civil or criminal actions. They, like the New Hampshire DOJ, have been following an education and voluntary compliance with Vermont's rules. And we really haven't focused on Vermont, but I at least want to give you a sense of sort of what's happening with our neighbors in terms of compliance. Maine has been a little tougher approach. So if your business touches on Maine, you might want to be a little bit more leery as to what the guidance are and sort of the following that guidance in Maine, because they've issued a few citations with regard to violation of their orders. And with that, I will turn it over to Lindsay for insurance considerations.
Thanks, Jennifer. Well, if you thought the workers' compensation discussion was dense, get ready because we're going to talk more about insurance. But a lot of people, I think at the beginning of the pandemic thought, oh, I have business interruption insurance. I have a business and it's been interrupted. This must apply, and I'm glad I have this types of insurance. But insurance is complicated and there's a lot of different types of insurance. You'll have various policies, and within those policies, there's different aspects to them. And so it's really important right now for businesses to understand how COVID can impact your insurance policies. You need to review what policies you currently have. If you have any questions about your insurance policies, consider consulting with a professional insurance agent or broker or your legal counsel who can actually go over your own documents, because while there are a lot of standard forms, each policy is going to have its own unique aspects to it for your individual business. You want to, in that process, identify any coverage gaps that you may have, and then determine what steps you need to take to help limit your risks and your losses so that hopefully you won't need to use the insurance. So those are some of the things we'll talk about. We'll go over some of those key insurance provisions to consider and some more practical tips. So as Jennifer mentioned, you have a few different areas of liability depending on who you're talking about. So this includes your employees, your customers and clients, your third-party vendors or contractors, if you have a third party helping provide temporary workers, and then you also may have shareholders if you're a larger organization. So those are some of the areas and the lenses that you need to be looking at this from. A lot of people will have general liability insurance, your commercial general liability insurance. And that protects you against those third-party claims that Jennifer was talking about. So not necessarily against your employees who would be turned more toward the workers' comp side of things, but toward any of those other third parties. And the key here is that this will typically apply to bodily injury and property damage, but that really is only if the bodily injury or property damage is caused by an occurrence that takes place. And so the key here is the word occurrence. And this is often defined as an accident, including continuous or repeated exposure to substantially the same general harmful conditions. And so people think, what does that mean? And really what you think of as an occurrence in layman's terms is it really is some sort of accident. And your general liability insurance coverage sometimes and most often does include both indemnity to cover the costs of either that bodily injury or property damage, as well as your defense costs. So that's one of the areas that you'll want to make sure you look at to see if you have indemnity and defense or just one or the other. It's important to know bodily injury when we're thinking of COVID. I think that part's usually pretty clear. If someone is sick and has a bodily injury due to COVID, that's more clear versus the property damage. And that's where some issues have come up. Property damage generally doesn't include pure economic harm. And so that's where some businesses that were shut down due to COVID and had economic harm thought that they may be able to recover, but really that may not qualify as property damage under your commercial general liability insurance. We do have some case law, and a lot of these you've probably seen in the news. A lot of these cases about whether insurance coverage applies are currently being litigated across the country. As Jennifer mentioned, I'm not aware of any prominent New Hampshire case law, and it really seems to depend on what jurisdiction you're in about how courts are viewing whether this policy, your certain policies would apply to COVID. But we do have some precedent from E. coli outbreaks, salmonella outbreaks, and things like that. So while they're a little different, they may help steer or preview how a court may consider a COVID coverage issue. In the E. coli outbreak cases, what we saw was there was some coverage, for example, if what you usually see is a restaurant serving food that was contaminated with E. coli. The problem is that may be different than an airborne disease, which again is maybe harder to prove for a claimant that your business somehow was contaminated with COVID. So those are some of the issues that are going to come up, but it's good to check your general liability insurance to see what's covered and to see if you have both indemnity and defense costs, so that if a claim does come, you're covered, and also the insurance carrier is also providing your defense costs if it does need to be litigated. Some common exclusions that apply to these general liability coverage are your communicable diseases, bacterial, viral, or both can be included. So you need to check to see certainly if viral is a communicable disease under the definitions of your policy. There's also exclusions for mold and fungus and other pathogens, and pollution exceptions also apply. So it really depends. And again, these are the types of things that are being litigated right now about whether COVID falls under any of these exclusions. And then the other exclusion is an expected or intended injury exclusion. So at the beginning of the pandemic, not a lot was known about how the virus spread and was passed along. And so this may not have been triggered as much, but as we know more, if a business, for example, is not cleaning high-touch surfaces regularly, isn't making sure they have a proper ventilation system, isn't requiring employees to do screenings before they come in, and someone does end up getting COVID due to the business, there may be an exclusion of coverage because it was expected. If you're not doing the things that we typically think of that are best practices, it's expected you would somehow have a COVID issue in your business. So you need to look at the expected or intended injury clauses and see if those exceptions would also apply in your coverage. And again, I think that stresses Jennifer's point, which is follow the guidelines so that you don't have that issue. I mentioned business interruption insurance previously. Most of your property insurance will include business interruption. The key here is that it's triggered by a direct physical loss or damage to property. So think of a hurricane comes through, there's a big fire, there's a theft that causes direct physical damage. So the question often comes up, is the virus or a pandemic a direct physical loss? And really it's going to be fact dependent on your business. And so again, you need to look at the policy wording, your exclusions, and your endorsements to see if a virus is excluded from this definition of direct physical loss. And again, pure economic harm probably wouldn't qualify as a direct physical loss. Now, if you had something that was more akin to an E. coli situation, or there was widespread contamination somehow, and certainly there can be an argument made that because COVID is airborne, that if there's such a high degree of it, that perhaps that could be a direct physical loss. Those arguments can be made, but it's really uncertain. There's a lot of pending litigation right now around these issues, but it does seem like that's an uphill battle for a claimant to bring. However, you want to check your business interruption policy to see if it's worth making a claim against your coverage. There's future legislation being considered, as Jennifer mentioned, in various states. New Hampshire doesn't have current legislation requiring basically that business interruption insurance cover COVID. I think even if such legislation were to be passed, it would probably be challenged in courts and has been in other states. So that's something that we'll keep an eye on. And as Jennifer mentioned, there is somewhat of a push at the federal level when looking at both sides of the issue to require carriers to cover business interruption insurance for COVID and also to provide immunity for businesses from having these claims brought. So there's a lot going on at the federal level as well. There's also insurance if your business is impacted by your supply chain being interrupted. And this is usually contingent business interruption insurance. So it covers not only interruptions to your business, but to anyone down your supply chain. So it would cover those lost profits or extra costs resulting from an interruption in business at a third party, such as one of your customers or one of your suppliers. Again, and you're going to get sick of hearing me say this, you need to check your policy for exact wording about your scope of coverage, because your policy may either name specific third parties about who this would apply to and be triggered under if they're impacted, or it could be broader to apply for all customers and all of your suppliers. So again, just check your policy and see if you need to tweak that coverage at all. It does usually, again, require some property damage, similar to your more traditional business interruption insurance. One thing that's come up a lot lately is cyber insurance. I experienced my first Zoom bomb the other day, which was terrifying. But cyber insurance is something that's coming up with more people working at home. Jennifer and I are both working at home today. You're having more phishing attacks, and you're also having people working at home with less secure internets and using their own personal devices maybe. So there are greater risks. You're going to have more data breaches, security breaches, privacy issues come up, those network shutdowns. You're going to have regulatory actions based on, whether it's your employees or your consumers' data being breached. So it's important to make sure that you're looking, and the world of technology is always changing, right? So you want to make sure that you're constantly updating your company's work from home policies, your security protocols. Do you have dual authentication to sign in places? Are you requiring employees to only use their work computers and not work on home computers? They're the only ones who can access them, that kind of thing. And check out a standalone cyber insurance policy. Some of your more general policies will touch on areas that may impact cyber insurance, but it's really good to consider having your own standalone cyber insurance policy to help cover some of these things if you are going to have employees continue working from home. And speaking of employees, there's employment practices liability insurance, and it covers situations where an employer executes either a partial layoff or furloughs or some other larger reduction in force, and then faces a lawsuit from an employee who claims that there's been discrimination or a wrongful termination of some kind. So if you are downsizing or think that maybe in your future, it would be good to submit notice to any potential claims to your carrier sooner than later. And again, I think this is an area, there's a lot of legal requirements when you're looking at doing layoffs or furloughs. I know Jennifer probably is very knowledgeable in this area as well. Really consult with employment counsel if you do have any questions before you have to take any of those actions. Travel and special event coverage. If you like to go on cruises, this would be something to consider. Businesses that had to cancel or change their employee travel plans should look at their travel insurance policies. Viruses may be excluded, but they may not, so you need to look at your specific coverage. There's also special event coverage, so that if you had to cancel or postpone your scheduled event, maybe you have one big event every year, you've already paid a caterer, you've already put deposits down for the venue, paid for travel or hotels for employees, that kind of thing. If that was canceled due to COVID, check to see if you have special event policies that would cover those costs. And usually disease-related issues are typically covered, but again, check those exclusions in your policy to make sure that it's covered. There are some vacancy provisions. So again, with a lot of people working remotely, some office buildings are empty or near empty. So you'll also want to see if your policies have any vacancy provisions. Some property insurance policies have either removed or can either remove or reduce coverage if a property is vacant for a certain number of time, like 60 days, 90 days. Some carriers have temporarily suspended this in an effort to encourage people to work remotely to help stop the spread of COVID. But as things are reopening and people are going back into work, carriers have begun reinstating these requirements. So check with your carrier if your office space is vacant or nearly vacant to make sure that you won't have a lapse in coverage because of that. There's also directors and officers insurance, D&O insurance. Right now, executives at the top are making really hard decisions. People are looking at, do we need to do furloughs or mass layoffs? how do we reopen and what protocols need to be in place. And so we may see an uptick in litigation with claims of mismanagement or disclosure related claims. And so that's where D&O coverage comes in, because it would cover for the liability of your directors and officers of your organization if those claims are brought. So that's one thing to also consider. So some practical tips about what you can do to prepare for a potential COVID claim. Really, I think it's preparation is key. And so if you're listening to this webinar, you're already on the right track. Check your policy renewal requirements, make sure that you don't have a lapse in coverage, and then create a process for responding to a loss before one occurs. And I can't stress enough that documentation here is key. You want to be able to show with documentation how a loss occurred, the impact it had on your business, all expenses associated with it, and how it might impact third parties. So really just make sure that you're writing all of this down somewhere. Seek a qualified insurance professional.
One thing I'll add, based on sort of all the litigation coverage and claims that we've done, is interview witnesses too. I mean, employees seem to be very mobile these days because their circumstances are changing so quickly. So if a loss has witnesses or needs witness statements, make sure that that's part of your documentation, because you could lose that employee the next week and they could move to their Montana to take care of their aging parent, and finding them and getting sort of information may be more difficult down the road.
It's a really good point. And especially as people are starting to be more mobile again, that will be really important. So seek out your qualified insurance professional, whether it's your broker or agent or legal counsel. Just really make sure that you understand what your policies and coverage are. And if you think that you have a claim, right, submit the notice of claim and preserve your rights. Better safe than sorry. So make sure that you do tell your carrier if there has been something that's come up. One thing that's come up a lot, and I know Jennifer and I have both had to sign these, are liability waivers and releases of claims. So the question we get most often is this worth doing? Should my business be asking people to sign one of these, or should I sign one of these? So they can apply to different people, again, your clients, vendors, contractors, employees, and there's going to be differences, again, among jurisdictions about whether these are upheld in a court of law or not. Practically, you also should be asking, is it a good idea to bother with one of these? But the basic concept is basically you're asking one of your clients, vendors, customers to acknowledge that the activity or service that they're about to participate in involves a certain degree of risk, and that they're not going to sue your business if they do get injured, if they do catch COVID, for example, even if it's the business's fault in some way. So I think we're seeing these, there were questions before, I think earlier in the pandemic, when restaurants started reopening, about whether a restaurant could ask you to sign a piece of paper before you sat down at your table. Those kinds of examples I think are extreme, but we're going to talk about them a little bit. And so this is a lot of legal jargon on the screen here, but here's a pretty standard example of a release and waiver. And basically the top part says, I promise that even if I'm harmed, I'm not going to turn around and sue you. And that the assumption of the risk piece says, I acknowledge and understand that I'm taking on these risks voluntarily. And so these are pretty standard. You can see it's a lot of lawyer talk, which is why I think there's some skepticism about whether expecting a layperson customer who walks into a business would be held to one of these, even if they did sign it. So for consumer waivers, I think the common example that you used to see a lot was if you went to get a ski lift ticket or a baseball ticket, on the back of your ticket used to be where there'd be all of this bold capital letter wording saying, I'm going to release any liability. And even if I fall down the mountain, the ski mountain isn't responsible. Now you may be seeing it at private schools, daycares, restaurants, hair salons, and gyms. More places may be trying to adopt them. So I think the key is to remember that a liability waiver or release is a contract. So the parties both need to understand the contract and need to have consideration. It's less likely to be enforced in court if it involves an essential business. So if it's a pharmacy or a grocery store that people have to go to, it's less likely to be enforced. It's also less likely to be enforced if it's really broadly worded and puts in all the responsibility on a customer to say, no matter what the business does, they won't be held responsible for anything and the customer assumes all the risks.
And Lindsay, can I interrupt you for 1 second? Because we just got a question in that I think fits really nicely into this segment is, can an employer require an employee to sign a liability waiver? I don't know if you want to take that, or I'm happy to. It's one of the frequently asked questions at the end, but it probably goes into the part right now.
You go for it, Jennifer.
So the answer is yes, you can. The consideration, and consideration is just anything that a person gives a value. It can be $1. I've often seen that written into a contract. It can be doing a task. Consideration is something you give in a contract. So an employee can be asked to sign a release or waiver, and the consideration the employer is giving is continued employment, and the consideration the employee is giving is to waive any claims. I think the advice that we've been giving to people is you certainly can consider that, but you also need to consider the ramifications of what it does to morale, what you're it almost creates a sort of us employer against them employees mentality. And we've weighed that against the workers' comp bar and workers' compensation analysis and the Attorney General's advisory opinion, and said that you probably don't necessarily need it to protect you from employee claims, but you could certainly get one from an employee, is our opinion. And again, Lindsay's going to talk about some of the challenges that can be made to these waivers and claims, duress, adhesion contracts. I think you're going to touch on that a little later, but the same applies to these employee-employer releases. And I don't know if there's anything else you want to add, Lindsay, to that, but.
I think that's right, Jennifer. And I think that's exactly what I was going to talk about next is a defense. So even if you do have a customer or an employee who signs a waiver and release, one of the things that may come back around is they're going to say, this was a contract of adhesion. I was forced to sign this. I didn't want to. It was against my will. I was under duress. And so if they're arguing that, and it is an overly broad, puts all the responsibility on the customer or the employee type of contract, it's going to be hard for a court to enforce that contract against the customer or employee as a general rule. So I think, as Jennifer mentioned, if a business is already taking the reasonable steps to lower risks of COVID, they're following the guidelines, following the CDC and the EOC's best practices, then I'm not sure how effective a waiver or release of claims will be or is needed. Some have argued that waivers help protect against frivolous lawsuits, so they're a deterrent. Frankly, I'm not sure. I think if someone wants to bring a frivolous lawsuit, they're going to bring a frivolous lawsuit. So I'm not sure how effective of a tool it is to prevent those. And the alternative, I think you can, think about the more practical steps that you can take if you don't want to have every customer who comes into your store sign a waiver. You can ask customers to adhere to their state and federal safety guidelines, post signage about what your business is doing to combat COVID, what you're doing to keep a clean, safe environment, and also note that you can't guarantee that all individuals in the space are free from COVID. And that seems like a reasonable middle ground for businesses. And we already touched on this, but employee waivers, again, enforcement's questionable due to that unequal bargaining power that we were talking about between an employer and employee that courts seem to catch on to. And again, ask if it's practical. You have the workers' compensation bar, and you may also be impacting employee morale or even deter employees from returning to work. So if you are in an industry where you're trying to get employees back to work in the physical space, this may deter employees from feeling safe and wanting to return to work. They may be asking, why do you need me to sign this? If you're taking reasonable steps, then why do I need to sign this? And I think, again, alternatives can be that you can, make sure you're requiring all of your employees to adhere to your COVID policies and protocols. Hopefully you've by now updated your COVID policies. You have a specific COVID policy. You're doing the employee screenings, where requiring employees to practice those social distancing measures, wearing face coverings when needed, that kind of thing. And make sure that you have employees sign an acknowledgement form that says, yes, I understand what these policies and protocols are, and I will follow them. Those are alternatives if you are interested to signing a liability waiver for employees. I think where liability waivers and releases of claims may come more in handy are with your third-party vendors and providers. And here I think communication is really key. Look at what relationships you have with third parties, whether it's suppliers or independent contractors, and inquire with them about what they're doing and what their own COVID protocols are. And then ask them to sign some sort of acknowledgement or agreement that they're also, when they're at your workspace, going to follow your own policies and protocols. You should ensure that your COVID policies and protocols state that they apply to third parties. And also review your contracts with third parties to address COVID issues. So you would want to include a waiver of liability language where the third party agrees that it's going to require its personnel to waive the right to sue your business for injuries and damages arising out of their services. They're going to arrange for communication and reporting of COVID symptoms or infections with you, so you're sharing information as needed. And I think it's always a good idea to require third-party vendors, COVID or not, to require proof of insurance. So those are some things to look at with your third-party vendor contracts. And Jennifer touched on this earlier. Some states have passed laws or issued executive orders giving businesses protection from COVID-related liability lawsuits. We don't have anything technically on the books in New Hampshire in terms of laws. There is discussion about state and federal laws in the future. Where those will lead, really no one knows. We do have one exception in New Hampshire. There's an attorney general opinion, and again, this is guidance, but it limits liability for health facilities. So those are your hospitals and nursing homes, long-term care facilities, residential facilities, for their staff and volunteers that engage in any emergency management activities, so long as they are complying with or reasonably attempting to comply with applicable state and emergency orders and rules. So there is a liability shield for healthcare facilities in New Hampshire right now under that opinion for the term of whenever the state of emergency goes until. And we have a couple of frequently asked questions, and I think we already got to this one, Jennifer.
Yes, I think we did. So I think we've answered that in terms of the workers' compensation protection, but legally you could. The one thing I do want to add, as long as this slide isn't on it, but as Lindsay was talking about, the other thing I've seen in reviewing some contracts is indemnification provisions put in also. Those seem to be a much more sort of aggressive, I guess, provision to have in there, that if the person, the third-party vendor, brought COVID-19 into the workplace through one of their employees or workers, and then you had suits arising from that, they would agree to pay all your costs and damages and reasonable defense costs related to those. So you can also consider, and as Lindsay points out, in those third-party vendor contracts, whether you want indemnification provisions as well. And there are a lot of it. I just a couple weeks ago did a wedding planner wanted, again, that's a sort of high risk activity these days, didn't used to be, but that's one where you have a very specific sort of relationship with a third party, and it lends itself nicely to a type of release provision in there that you can get from the bride and groom as they're hiring. Query, again, I think this is always going to be the analysis of how far do you want to take it? Do you also want to get the guests to sign it? Do you want to have all the vendors who are going to be attending the wedding sign it? But that's a good example of sort of looking at your business model and seeing where your exposures are, and then determining, do I have insurance to cover it? Do I have the proper contract provision, or are there sort of laws in place that limit my exposure in that direction? And I think that's the general analysis that I hope you'll take out of the seminar in making sort of those decisions. And I think we covered this. Can I have customers, clients sign a release? And I think, Lindsay, you covered that very well in terms of the release language. So I'm not sure if there's more there to address. You want to take that one?
Sure. So I think one of the things really to limit your liability is remember to follow the guidelines, and that means having a plan and planning ahead. So if you do have an employee who develops COVID symptoms at work, make sure you look at your plan. The first thing should be to tell them to go home. They need to leave immediately and seek medical advice. And then you need to follow your protocols in place, which include disinfecting the employee's workspace, and also remembering to maintain confidentiality of any employee health information. So making sure that you are not disclosing any personal information while you are following that COVID plan after an employee has left work because they do have symptoms. So I think that's really step one for a lot of businesses that are reopening, is to develop a plan, follow your plan. And that way you can show that you're taking reasonable steps, following the latest guidance, you're staying up to date with the guidance, and that you've taken all reasonable steps to combat COVID in your workplace. And I think that's all we had. I know we have a couple minutes. Was there anything else, Jennifer?
I've been looking at the question and answer, and I do not see any further questions. So if anybody, if an employee gets sick, should an employer require other employees to be tested?
So I think if an employee does get sick, an employer can choose to do contact tracing to look at whether there have been employees who have been in close continual contact with that sick employee, and can ask, and it can be part of your COVID policy, that if that is the case, you're going to require them to work remotely for 14 days or work remotely until they have a negative test result or something like that. I think you could require it. I think it's always also helpful for policies to be flexible. So it may be something that you want to leave as an option, but maybe not a requirement in every scenario. It could be fact dependent. What do you think, Jennifer?
Yeah, and I just want to add, because this question came up to us, or to me in practice a couple of weeks ago, and I think you can sort of require, likening it to a mandatory drug test. Neither the EEOC nor the DOL, the US DOL, have issued any guidance on who pays, but you can administer COVID-19 tests that are job related and consistent with business necessity. That's the sort of language that gets you the ability to do it. Now, I think the big issue is the cost factor for both the test as well as the employee time. And I would stress to people that you probably first want to cover, check with your health insurance plan to see whether it's covered, because under both the FFCRA and the CARES Act, the individual and group health insurance policies generally cover the cost of COVID-19 tests under certain circumstances, but not the mandatory employment testing. So I think the good sort of practice is you're probably not going to get health insurance coverage for that. So as an employer, if you're mandating it, you need to cover the costs, and you also need to cover the employee time to go and take the tests. But again, I'm not sure I'm aware of any guidance, although there may be some in the industry specific guidance that requires that sort of contact tracing and testing. I would not want to opine on that. You should double check all the guidelines, but certainly in terms of the cost, you ought to be paying for it as the employer.
And again, remember not to disclose any personal information of the employee who does have a confirmed case when you're doing your contact tracing to other employees.
Yeah, and then we have one more quick question if we have 1 minute. I keep hearing about businesses closing and deep cleaning when an employee gets COVID-19. Do you have to close? Can't you just clean? And what does deep cleaning mean? I actually have not looked at that legal issue of sort of whether guidance it has anything that gives direction on that. Lindsay, I don't know if you feel.
I don't think closing is necessary under the guidance. You're right that cleaning is what's required under the state guidance. So you definitely want to make sure you're cleaning. I think it depends on what the exposure was to the whole building. So if it's someone who works in their own office and they have the door closed and there's really only one space that's probably been contaminated, you could probably get away with just cleaning. If it's a larger situation where there's been more widespread contamination, you may want to close for a day to allow a greater level of disinfecting. And I think we've seen that in how schools have responded. Some schools have closed down for a day or two to completely deep clean. Some schools have said, we did our contact tracing, it wasn't that widespread, we're moving on with our plan. So I think it's really fact dependent, but no, I don't think you're required to close.
Yeah, and I just would stress to you within your business, look at, again, both the universal guidelines as to what happened and what the requirements are, and then any industry specific guidance at both the state and federal level to make sure you're complying with what needs to happen, because I think there may be different standards and they may tomorrow after we finish this webinar change. So you need to be careful in looking at those applicable websites and really making sure you're following those guidelines to limit your liability and your exposure. And I think we're at 11:01. I want to be mindful of everybody's time. And Emily, you had one final sort of statement or closing remarks. So
yeah, first off, thank you so much, Lindsay and Jennifer. There was so much info packed in here. I want to let everyone know that we've recorded today's session, so we'll send you a follow-up email with that video along with today's slides and a link to Orr and Reno's blog, which has some really wonderful resources for you. I just want to quickly let you know about a couple other chamber events coming up. This Thursday, we have a webinar about personal finances. This is a great resource to share with your employees if you don't offer financial education to your employees. So consider that. That's this Thursday. We're going to be kicking off an entire series of webinars addressing mental health with Riverbend. So the first one's a week from today on October 6th. So keep your eye out for that. And if you are interested in doing some online networking, you can do that at our business during hours event. That's on October 13th. These have been really popular. People love socializing with each other online, so consider taking a look at that. Once again, thank you so much, Lindsay and Jennifer, for sharing your time and this great presentation.
thank you, everybody.